Mr. Krasner.
Good morning. May it please the Court, my name is James Krasner, and I represent the defendant, John Kendrick, who is the appellant in this matter. This matter is here on the granting of a motion for further appellate review by this Court after an adverse decision was rendered by Associate Justice Berry as the writer in the appeals court. The case concerns the central issue of no contact with children and what does no contact mean under the words and as applied to this case. Mr. Kendrick, in January 2000, signed probation conditions that indicated, from Middlesex, no contact with children under 16. That's at page 11 of the record appendix. On January 21, 2000, he signed no contact, have no direct or indirect contact with, names, close paren, victims and family, all minors under 16, and that was with the Clinton District Court, page 12, record appendix. He was monitored by the Worcester Superior Court, and the monitoring resulted in no incident until he was charged with this violation for taking his antique car to an antique show at Herbert's Candy Shop, where he stood at or near his car. He had his dog with him, and he was videotaped there for approximately 20 of the minutes of the 60 minutes that he was there. There was no showing during that period of time and no testimony by a police officer who observed him during that period of time that he had any communication of any kind, physical contact or touching of any kind, interaction of any kind with any children, other than children were there. Some with their parents.
Excuse me, Mr. Krasner, you quote a definition in your brief from Webster's New World Dictionary that defines contact as including, quote, being in association with.
That's right.
Okay.
But association has to mean more than just physical presence. I may be in association with you at the present time, but if I see you across the room at a bar association dinner that has 300 people, I'm not in association with you at that point, not as a clear meaning of that term.
Isn't that a question?
If it's a question, Your Honor, then it's ambiguous. And if it's an ambiguity, a probationer should be told by his probation officer so that the ambiguity is rid of. And that didn't happen here. He was supervised by Worcester Superior Court. They never said no car shows. There were certain ones they discussed with him that were obvious. You can't go to the beach during the day. Kids are usually at the beach. And
but if he couldn't go to the beach because kids are usually at the beach, he was outside a candy store.
But a candy store at night, Your Honor, and who knows what to anticipate. The way this opinion is written, it means that he would not be able to go to the barber shop if a child were getting a haircut. He would not be able to be in the supermarket aisle when he spots a child if he's getting his groceries. He was not under house arrest. He was permitted to leave for normal purposes.
But
I think there's a big
what did he tell his witness, Dr. Bartlett? Did he tell his Dr. Bartlett something about he couldn't be within 40 feet of children?
No, not 40 feet.
What
He
did he
said
say?
he couldn't be within the proximity of children, and the children were approximately 40 feet away. And that was, in part, when he's addressing Dr. Bartlett, because Dr. Bartlett could have brought his grandchildren closer.
But if he knew enough to tell Dr. Bartlett that he couldn't be within proximity 40 feet of children, then why didn't he know it when he was at the candy store?
Because he didn't know that they were going to be there, just as he didn't
But
know.
once he saw them...
Once he saw them, he took no steps to come in contact with them.
You
And
just
they
told
were-
me that when you were discussing it before, you said that he didn't know that he couldn't be near children, but yet he seems to have told his own friend, Dr. Bartlett, that he couldn't be within 40 feet of them.
He knew he couldn't be in contact with children.
No, that's not what he told. He told Dr. Bartlett he couldn't be within 40 feet of them.
And that's certainly a colloquial way of expressing yourself to a friend. You're reading an awful lot into the exact language as if Mr. Kendrick were an attorney. He is not, and he never was.
Mr. Krasner, what
Yes,
was the evidence at the probation revocation hearing?
The evidence at the probation revocation hearing, Your Honor, consisted of three separate things. It consisted of the testimony of Mr. O'Donnell, who was the chief probation officer of the Clinton District Court. Mr. O'Donnell merely testified that he received a phone call from a police officer who indicated that Mr. Kendrick had been on that evening at the Hebert's Candy Shop. He indicated that he reviewed Mr. Kendrick's probation records, someone's notes, not his own, and also testified as to Mr. Kendrick's alleged modus operandi, however, carefully selecting only the information that benefited his side, as it were. And
where was that information drawn from? The probation notes?
I would assume the probation notes. It's never clearly identified in the record. Mr. Kendrick clearly had used a modus operandi of trying to attract children with an antique car and a dog. If you read carefully the entire modus operandi, you find that comes much later. He met most of these kids through their parents at a church group, enticed them, offered them rides on the antique cars, and only later, the earliest time is about a year and a half into a relationship with this family, would he offer to take them alone on a camping trip or on a day boating trip. It was remarked, and it was shown in medical testimony as well. Available.
Why isn't that a subject? A probation officer is taking the stand. Why isn't that a subject of cross-examination?
It was. However, he says he doesn't really know. If you read his testimony...
Excuse me, who's the he?
Mr. O'Donnell.
Probation officer.
Says he doesn't really know.
He doesn't know how this modus operandi works other than that. And indeed, he says he read through the notes once. He wasn't willing to read through the notes again and pick up the detail.
What about the videotape? Was that shown at the hearing?
The videotape, I asked that it be introduced into evidence. It was marked. It was also viewed by the appeals court. It's approximately 20 minutes long, and the judge who had the hearing in the Clinton District Court said that she viewed it after the conclusion of day one of the hearing, but before the beginning of day two.
What is the Crawford issue? What do you claim is the Crawford issue here?
The Crawford issue I claim actually that should be addressed is that they never brought in the supervising probation officer.
Well, you saw the videotape. The videotape, I assume, and you offered it.
Yes.
Did the videotape show what the claimed violation was?
The videotape showed what I claim to be entirely exculpatory. Mr. Kendrick was not in contact with any children. He was not shown to be in communication with any children. He wasn't standing close enough.
Was he in proximity to children?
Proximity, it depends upon what you mean. According to the police officer who testified at this hearing, in close proximity meant she was 25 feet away from him, but that's how she called it. When I questioned Mr. O'Donnell as to whether or not any child on that videotape was within 5 feet of Mr. Kendrick, he evaded, bobbed, and weaved, and finally he said at least 10 to 15 feet.
Okay, could you help me? Because I'm just not clear. Are you suggesting that the probation officer or police officer testified to something more than was shown on the videotape?
The probation officer relied on the videotape, but drew conclusions from it that it was a violation. When asked any of the details, did he approach them? Did he touch them? Did he talk to parents who were holding their kids' hands? He would provide almost none of those details.
So I'm asking you, what is the Crawford violation?
The Crawford violation, I believe, is that his own probation officer should have been there for two reasons. One, to show the extent of the supervision and to show that this no-contact issue in this way had not come up. Indeed, and it's nowhere part of the record, and I only learned
Well, how would his probation officer know that there had been no contact that night if he or she, I don't know what it was, hadn't been there, and all you have is the videotape?
No, I'm talking about any conversations between Mr. Kendrick and the probation officer relating to no contact was certainly important. And the reason it was important is spelled out and shown in Commonwealth versus Tate. In Tate, the reason when the guy stands at the top of the hill and looks down at this woman who was a victim who he had approached the day before, and one of the reasons the court relied so heavily on it was he had had conversations with the probation officer that basically said, look, you can't go anywhere near this lady.
Were there any eyewitnesses to the car outside the candy store that testified at the violation of probation hearing?
Only the police officer who was physically present on that evening. She was not the photographer, the videotaper. She had called for the videotaper to come, but she was on a detail at the candy store. She observed Mr. Kendrick there. It's a small town, Bolton. She knew that Mr. Kendrick was not supposed to be in the company of children, she said.
And was the probation officer's testimony based upon either Mr. O'Donnell's or the supervising probation officer's viewing of the videotape?
Yes, Mr. O'Donnell, who was the chief probation officer, viewed it.
So the judge was in as good a position as both probation officers to ascertain what the facts were based upon what was disclosed on the videotape.
But only the supervising officer could testify as to
I'm only talking about the scene, at the scene of
The scene is the videotape for 20 of the 60 minutes.
All right.
The police officer who testified, and not directly said this, but I think indirectly when you read her testimony, indicates that for the next 40 minutes it was still the same. She saw no contact.
To go back to the what the word contact means, have any of our cases defined it in this area?
I think that they haven't given a dictionary meaning, but it is clear that all of the cases, and I summarized them in my brief, involve some kind of communication, of physical touching.
Because that would make sense. Otherwise, the word contact by itself would bar someone like this defendant and others similarly situated from going anywhere.
And that's exactly what
there are
Mr.
children everywhere. He couldn't go down and do holiday shopping at Filene's because there are children there. He couldn't go watch a baseball game at Fenway Park because there's children there.
I asked Mr. O'Donnell what Mr. Kendrick was supposed to do if he was walking down the street to go mail a letter, and there was a child walking on the other side during school hours, and that child was of school age. And he said he's to turn around directly and go home. He's to be out of the physical sight of children.
Well, then that doesn't make any sense, because he couldn't go anywhere. He couldn't go to church. He couldn't go to anywhere.
And yet he had been permitted to up to that point. In fact, the judge who heard this hearing imposed a further condition to rid it of the ambiguity and said, if you come into the presence of children between this first hearing and the date I sentence you, or find you not in violation, you are to leave immediately.
He couldn't go to the supermarket.
That's correct.
So, but what you are suggesting, Mr. Klasner, is that there was an ambiguity which has now been, quote, clarified. Whether or not it's a permissible clarification is not before us.
Well, the clarification the judge added in, she added in after she was already in the middle of a probation hearing, only because it had to be continued.
Correct. But
my argument is that the ambiguity existed at the moment of violation, alleged violation.
I understand that. Is the scope of the additional condition before us on this appeal?
No.
Okay. Can I ask you one other thing, Mr. Klasner? The Commonwealth takes the position that the Crawford prohibition does not apply at all in probation revocation hearings, that it is only at the criminal trial itself, the guilt-innocent trial. What is your response to that? Leaving aside whether or not this particular modus operandi testimony would or would not qualify for Crawford protection.
My response is as follows, Your Honor. I agree with the brief filed by Mr. Iovino that probation revocation hearings are hearings that certainly should be characterized as semi-criminal trials. Why? They result in some kind of sentence or punishment of a human being. It's clear under both Gagnon versus Schiaparelli and Morrissey versus Brewer that constitutional rights of some, less than the full panoply at a criminal trial, but some constitutional rights apply, including the right of confrontation.
But what's the origin? Is the origin of the right of confrontation in those cases the Sixth Amendment, or is it due process?
I believe, Your Honor, in Gagnon and Morrissey, it is due process, but we have to go back to Poynter versus Texas, which holds that the Sixth Amendment right of confrontation is constitutionally read through the federal due process clause under Poynter versus Texas.
But we grant the right of confrontation and cross-examination under the due process clause to civil hearings. We grant them to consumer hearings.
I understand, but now, post-Crawford, the issue is reliability of the information that comes in, and that brings the problem up anew. Before Crawford, it was settled that the rights we had in any probation revocation hearing were those rights that were limited to whatever Gagnon and Morrissey and the Supreme Judicial Court provided, and they had already enunciated those rights. But those rights always included the reliable information that had come in a hearsay nature.
Thank you, Mr. Klasner.
Thank you.
Mr. Hodgins? Mr. Hodgins, you can use the time any way you choose to, but it would be helpful if you could just address that last point, which is why Crawford should not be applicable at all at a probation revocation hearing.
Certainly. About a week and a half ago, the First Circuit in the United States versus Rondo seemed to foreclose the possibility of applying Crawford outside of the context of a criminal prosecution.
Right.
Indeed, the First Circuit wouldn't even apply Crawford to a sentencing hearing, would it?
That's correct. Post-trial, it doesn't apply. So as a matter of federal law, that issue seems to have been recently resolved.
Well, it's not resolved. It's
Persuasive.
It's persuasive.
Well, are there any circuits that have resolved it otherwise?
Actually, my understanding is of the 5 circuits that have addressed it, they have all agreed not to apply Crawford. So it's very persuasive authority under federal law. And it makes sense, too, if you look at the reasoning that those courts used, the plain language of the Sixth Amendment applies to criminal prosecutions. And
I think before Crawford, you probably would have gotten all the circuits to agree also that the right of confrontation didn't encompass the application that Crawford gave it to spontaneous utterances. So I don't know how much reliance we can place on the circuits, so that's all we got, I guess.
the sand is certainly shifting beneath us, but I think we can rely on...
I mean, there are, you would agree, I think, with Mr. Krasno, considerable criminal overtones to a probation revocation proceeding, because if the fellow is violated, person's violated, you end up with the imposition of the original sentence, correct?
Absolutely. It does have, as Judge Lawrence in the appeals court put it in the Morse case, it's kind of a quasi-criminal or civil proceeding. It's not quite criminal, but it certainly gets close to it.
The consequences are in
absolutely.
essence,
There's a liberty interest at stake,
criminal,
no doubt.
What are the civil aspects of it? I don't see any civil aspects to it. It's all conjoined to a criminal case.
Well, that was the language that he had used in the Morse case. I think he was just emphasizing that it's a non-criminal matter, and that's been said repeatedly by this court, by the United States Supreme Court.
It's also that liberty is not at stake in the same sense. When you're on probation or parole, it's conditional liberty.
Absolutely. And this speaks to Justice Greeny's concern about the no-contact provision, that it appears very onerous, but we have to look at it in context. The defendant, Mr. Kendrick, is a convicted sex offender. He has already been prosecuted for that. It makes little sense to gear up the machinery for a criminal trial to go through that sort of exercise again. The judge had the authority to imprison him if he wanted to, if the initial judge who took the plea, if he wanted to imprison Mr. Kendrick, he could have, but he didn't. In the language that this Court has used in Durling, through the grace of the government, he did not do that, and he opted to put him on probation.
Let me ask you this, in pursuance of Chief Justice Marshall and Justice Graney's questions. Here, the probation condition that was violated was sort of a no contact, just for short. But what if the violation had been a new offense? Say it was an assault and battery on an adult. He could have, the probation surrender hearing could have been on the basis of a new offense. And then the judge would have had to determine, on a standard of less than beyond a reasonable doubt, whether the probationer had committed that new offense. And if the judge determined that indeed the probationer had, then probation could justifiably have been revoked. And how is that distinguishable from a criminal proceeding? I mean, why then shouldn't the full panoply of constitutional rights apply?
This was a special condition of probation.
I understand, but I'm just changing the facts of it.
The one that you're referring to
Yes.
would be the general condition, which appears before it on the form.
But there wouldn't be a different, I'm asking what would happen then as far as Crawford is concerned. Because you're arguing it's non-criminal in nature, it's civil, it's more like civil.
It's still non-criminal. It is still a non-criminal proceeding.
Why?
Because it's an order of the court that has been violated. The underlying crime is not at issue. That can be a separate...
No, I understand
Put it this
that.
way. Let's assume that the charge, the violation, assault and battery, and what you have is no witness to the act. You have a police officer who actually didn't even file the report. You know, so you can tote and pole the hearsay as much as you want to, and your position would be that's okay because this is a quasi-criminal civil proceeding and Crawford just doesn't apply. In other words, you don't have to get the actual eyewitnesses in.
Well, because there will be a time for confrontation, and that would be in the criminal proceeding. So there would be an opportunity to confront the witnesses against him should the probationer then be subject to a criminal prosecution down the road.
But what if the Commonwealth chooses not to prosecute him? In other words, let's assume that you've got, fairly lengthy sentence, 3 to 5 years or whatever it is, and the Commonwealth wants him incarcerated, can do it by, a police report, and he then serves 3 to 5 years, and the Commonwealth doesn't choose to indict him or, bring a complaint on the assault and battery or whatever the unrelated conduct is.
Well, I think it's because a probation matter, the fundamental difference between probation and a criminal prosecution. If probation seeks to go forward on a probation violation, the purpose is essentially to vindicate the violation of an order of the trial court. It does not involve the prosecutor's office at all, generally. We're not going to be getting involved in that. That's strictly a question of the discretion of the court. Has this person violated this order, and should additional measures be taken to assist the defendant, to assist the probationer in trying to get his life straightened out, to either avoid incarceration or to...
Let me give you this hypothetical, Mr. Hodgins. Probation officer or police officer gets a call from somebody, telephone call, saying, I just saw Kendrick slug a man on the street. There was an altercation. I saw him step up to him and just, swing one, and there appeared to be blood coming from the mouth. And this report gets filed, and it gets into the hands of the probation officer. The probation officer goes to Kendrick, and Kendrick said, I didn't do it. And maybe the probation officer contacts the person, maybe not, but there's a report filed. Probation revocation. Probation officer gets up and says, I got a report that he, assaulted somebody. And he said, I didn't do it.
Well, we have an extensive body of law that does deal with that. Under Durling, Gagnon
Right.
v. Scarpelli, it's the word of the probation officer is not necessarily going to be taken by the judge. That still has to be tested in somewhat of an adversarial process, although
And
it doesn't.
how is that tested?
Well, it has to, I take it the judge has to make a determination that that is reliable. And
Reliability.
indeed, if that is the only basis for the revocation hearsay, it better be very reliable.
Well,
At least that's
Absolutely.
what our case law says.
Absolutely. So we do have a body of law that
I
is
I
unchanged
understand,
by
but
Crawford.
Crawford would say you have to get the witness in.
That's
So
right.
the judge, the judge listens to the probation officer, and the probation officer says, I went to talk to this, person who reported, the citizen who reported it. The citizen knows Kendrick, but doesn't have any adverse relationship with Kendrick, and why shouldn't we require the Commonwealth to bring that witness in?
Well, I guess it would all depend on how much this court wants to adhere to the policy that it has followed for generations now, and that is to keep probation a simplified procedure, keep it focused on rehabilitation more than punishment, and really to keep the prosecutors out of it unless they are invited in by probation. If we're going to start applying the same sort of rules of evidence that we have in trials and inviting...
No, it's really...
In the same standard, reasonable doubt? I mean, if we're going to call this a criminal proceeding, why aren't all of the rights incorporated into it? Why not?
It would fundamentally change
I
probation.
understand. What I find of interest is that Crawford, albeit in the context of a criminal trial, says evidence is not reliable unless it's tested. Under Durling, etc., we say it has to be reliable. I'm not saying that you have all of the rights. I'm saying we have a pretty powerful statement based on very strong historical precedent that Crawford essentially relies on reliability. It's not reliable. And that's how we got to spontaneous utterances. It's not reliable unless you have an opportunity to cross-examine. Durling says it has to be reliable. So I'm not asking whether this is you get the full panoply of rights. I'm asking how we can say something is reliable when we've got a pretty strong precedent saying it's not reliable unless you can actually confront the person who observed.
Well, again, I think that if you were to create such a rule, it certainly wouldn't be based on the Sixth Amendment. Well, that is clearly directed toward trials. If you want to turn probation hearings into mini trials, it wouldn't be based on Crawford. It wouldn't be based on a need for reliability because those issues are resolved every day in the trial court. Judges wrestle with those questions all the time as to what hearsay is reliable.
If such rules were imposed, do you think it would change the frequency with which probation is imposed?
I think it would definitely have a chilling effect on trial judges at sentencing if they have a concern that perhaps they're inviting a mini trial and we're going to be, parsing the language of what the no contact order said and so forth. I think that judges might be.
That's a separate issue.
Well, I think that judges might be reluctant to consider non-incarceration.
We have no, I mean, that's hypothesis. You don't
It is.
know.
Oh, absolutely. I'm just
May I
responding to
ask-
the question.
No, I understand, but there's no evidence one way or
No.
the other.
No.
May I ask you a different kind of question? It has to do with a person who's given a no-contact order. How are they to function in society where they're likely to run into children in any activity once they leave their home?
At first blush, it does seem to be a very onerous restriction. But again, looking at the person we're dealing with, the restriction is tailored to this individual by the judge.
So what is that individual to do?
Well, I think implicit in no contact, in that order, it should be an understanding that you are not to initiate contact It's one thing if a child comes to your door and rings your doorbell, you're not responsible for that. I think common sense.
Well, to go back to a point your brother was making, let's say this person is walking down the street and they see a child coming towards him. What are they to do?
The second part of that, the first part would be don't initiate. I think the second part would be if contact is made, you have an obligation to disengage that contact. I think that is implicit.
So is there any arena they can go to where they're not likely to cross paths with children?
There are arenas, but you are limited. Again.
So upon seeing a child, they're to remove themselves.
That's correct. In fact, he did that in the case in dealing with his friend, the doctor, Dr. Bartlett. He should have done that at the car show as well. Once he got there and he saw that there's children everywhere, as you'll see in the video.
But you can see that there's almost no place where a child might not appear.
Well, in modern society, we have, if he needs to go shopping, you can shop at off hours. You can, this happened during the summer too.
Well, I take it you would concede that accidental or inadvertent contact wouldn't be covered by this order. I'm in the grocery store looking for, frozen food, and a family with some children come by, and they're looking for frozen food too. That wouldn't be covered by this order.
Common sense, I think, controls.
Isn't the distinction in this case that the judge found on the evidence that he deliberately positioned himself where children would be? That this was not unintended or inadvertent. This was a contrived circumstance. He knew children would be there. He knew they'd be attracted to his dog and his car. He deliberately positioned himself to be in the presence of those children, and that's what the court found. Doesn't that distinguish this case, you think?
That is exactly what should be the controlling fact in this case. He brought all of these circumstances about. He was not just attending the car show. He entered the car show. He put his car in the show, inviting people to come and look at it. A very different matter than just going to the candy store to buy a box of candy. He was in the show. He was inviting people to come and look at his dog and his car. That's what the distinguishing factor is in this case.
Thank you, Mr. Hodgins.
Thank you.